Judge Agee, do you have any questions of Mr. Patel? Judge Wynn, do you have any questions?
No questions.
All right. Thank you very much.
Thank you.
Rebuttal? I don't know what there is to rebut.
I usually have a lot of words, but not today.
Okay. Well, I want to thank you both for being here, and it's an interesting case, and we wanted to give you the chance to explain your positions and to have a situation open for counsel if needed. All right, we thank you both, and we'll proceed directly into our next case.
Thank you.
And we will versus Sony, and we will be happy to hear is Mr. Boland. Whenever you're ready, Mr. Boland, we'd be glad to hear from you.
Yes, ma'am. Good morning. Your Honor, may it please the court. The defendants in this case submitted a competing bid against their current employer, AdNet, in a head-to-head competition for a tangible, specific subcontract with General Dynamics. In addition, they caused the competition in the first place. That was otherwise on track to be a sole source award and was likely to be a sole source subcontract to AdNet until AdNet's 3 employees approached General Dynamics and diverted that opportunity. I'd like to address, on the duty of loyalty, I'd like to address 2 primary points in errors that in the district court's decision below. First, the district court erred by misreading Williams versus Dominion to hold that the duty of loyalty in Virginia.
Can you pull that microphone a little closer?
Certainly, I apologize, Your Honor. The district court erred by misreading Williams and Dominion to hold that the duty of loyalty in Virginia, that the duty that employees owe their employer, is limited to just 3 types of conduct: misuse of confidential information, misappropriation of trade secrets, and solicitation of clients. Those are 3 examples that the Virginia Supreme Court in Fetterman has found to be clearly a violation of the duty of loyalty, but those are not the only ones. Fetterman made clear that it's a case-by-case analysis, that a district court and ultimately a jury has to consider the totality of defendants' actions to determine if they breach the duty of loyalty. The district court misread Williams, and with that mistake, concluded that the only question, that's a quote, the only question raised in AdNet's case was therefore whether AdNet solicited or the defendant solicited one of AdNet's clients. And that was an extremely narrow a review of the case, and it ultimately led the district court to ignore the most obvious facts, which is the defendants here actually competed against AdNet. This was a direct competition, head-to-head, for a General Dynamics subcontract. They did it while still employed. As a matter of
counsel, were there any contractual restrictions on the ability of these employees to look for work?
Your Honor, no, they were not contractually limited. If they wanted to resign, they were free to do that. They could have resigned and competed against
And
that.
I didn't ask about, I know whether they were free to resign. That wasn't my question. I said, were there any contractual restrictions on their ability to look for work during their employment?
No, there was not. They were not contractually limited. They were able to, and in fact, I think Virginia law recognizes they're able to look for work, but they cannot compete directly against their employer while still employed. And
Well, how are they, I'm not sure how were they competing, because Advent didn't have a General Dynamics as a current client. Maybe you would have a different case if General Dynamics had been a current client of Advent, but he wasn't. So what's wrong with competing in that situation where the General Dynamics has made no decision to whom it's going to award the contract?
Your Honor, the duty of loyalty is not limited to situations where employees might be soliciting a current client. That is one example, but it's not the only one. And in this instance, I want to make a very important clarification here. The three defendants here were not looking for work. They were not looking for just employment. This is not just an employee changing employers. They used their own company, their own LLC, to bid against AdNet. The competition, there was a solicitation issued by General Dynamics. AdNet submitted a proposal, and unbeknownst to AdNet, it's his own employees submitted a competing proposal for a company to win the same work. It was a head-to-head competition. It is the definition competition. And while I also believe that you could sort of characterize this as a form of soliciting an AdNet prospective client, we don't even need to get that far. This is just a head-to-head competition, which is a direct violation of the duty of loyalty. It's not.
Is that the biggest distinction between this and the Williams case, is the fact that there's competitive bidding in this case, whereas in Williams, there's no evidence that they were simultaneously reaching out to a third party and competing for this work opportunity?
Your Honor, yes, I would say that is one of two.
Why should that make a difference in our determination of Williams' application?
Because Williams was an individual. He was simply changing. That Williams is really a case about an employee changing employers. His employer Dominion did not know about this potential future work between Steele and ACS. ACS initiated the contact and ACS solicited Williams to say, hey, come, when he found out that he wasn't satisfied, to say, come join us. It's an employee finding new work with a new employer. In that instance, there was some harm to Dominion in the sense that probably Dominion lost the work because Williams.
But what's wrong with a competitive bidding situation? It would seem to me that competition for a contract that Advent decided to compete the contract. What's wrong? It would seem to me to be socially beneficial to have a competitive bidding situation and allow the General Dynamics to get the contract at what was relatively a lower price. I mean, we all through government contracting and private contracting, we sing the praises of competitive bidding. Competition's a good idea. It's a good thing.
Right, Your Honor. So I would have two responses to that. One, this was not just individuals changing. This was a company, and it was more than just the three. The contract was for minimum of 4 individuals. So as part of taking that work from that was poised to go to AdNet and over to their own company, they also solicited one of AdNet's employees, Michael Adams, and so it was not just their own individuals looking for employment. But in terms of your broader question about the policy, this case is not implicate the value of competition in government contracting or anywhere else. If General Dynamics wanted to compete this subcontract, they could have. General Dynamics had no limitation. In fact, General Dynamics could have hired these individuals as employees if they wanted to. They've never expressed that interest. The employees could have left AdNet and become employees of General Dynamics. This case wouldn't be here, but they didn't. And the simple fact is, under Virginia law, which follows the restatement of agency, there's a fiduciary duty owed to the employer. And the only issue.
Let me ask you a question, because this is that issue is sort of keen here, and I want to get a clear understanding in terms of your position and maybe the position of the other side. If there is a competing contract bidding by employees of your client, the question becomes, are they putting themselves in direct competition with your client, which in case that may be something a jury could say is a breach of the duty, or whether the jury would find that the participation in this bid was more like a preparation rather than an actual competition. As I see the possibility, that I think is a close question, to be honest with you. I don't know which way it goes right now, but I'm trying to determine, because this is a question of whether there is a jury question that can be derived from the fact that, unlike in Williams, there's a competitive bidding process here. And in that process, they are actually employees of AdNet competing with them. And the question then becomes not contractually, but is that sufficient for a jury, a reasonable jury, to find that would be a breach of fiduciary duty of loyalty?
Right. I agree. I think absolutely that is a question for the jury to decide. There are a lot of questions in this case. Under Fetterman, it's a totality of the defendant's actions. That's what the jury has to decide.
But what brings this on the second time in terms of the jury being able to make a determination of whether there was a preparation of an actual competition? What are the acts that makes this something other than a preparation to compete or actual competition?
I mean, the key is that it was actually a competitive. I want to back up. They also caused the competition, but just moving beyond that, it went from a sole source to a competitive environment.
They submitted their own bid, didn't they?
What's that?
They submitted their own bid.
The employees did?
Yes.
Yes.
Isn't that the answer to Judge Wynn's question?
Yes. I mean, ultimately, it's you're both competing for the same. You're both affirmatively acting, trying to take the contract by the defendants submitting their bid. They're essentially saying, give us the work instead of our current employee.
Well, I had a question about the elements of the breach of fiduciary loyalty tort here. The district court seemed to indicate that an element of that claim was that there be some sort of a business expectancy. I don't find that in the Virginia cases as an element. What's your view?
Your Honor, I would agree, and I think that's where I think the way I trace the district court's analysis, I think that because the district court made that initial misreading of the Williams case as limiting the duty of loyalty to one of those three types of conduct, and the third was the solicitation of employees or prospective clients. I think that's why the district court sort of analyzed the duty of loyalty just in that narrow context, as if AdNet had to show that it was going to get this work from General Dynamics. It was an existing client that it was essentially certain. And
well, I guess my question is, if the district court added an element to the claim that's not valid under Virginia law, isn't that an error in and of itself?
Yes, Your Honor, that would be. If there's no other questions on the duty of loyalty, may I shift just briefly over to the.
Well, let me ask you on that question, just to be clear. Is it contention that the district court did that for the breach of loyalty, not regarding the tortious interference, because it appears that is an element under that? Is that?
That's right, Your Honor. Okay. Yes. Yes. There's overlap between the district court's analysis of the duty of loyalty and then the interference. And just if I may just briefly touch on the interference. we believe the district court erred by essentially holding ADNET to a standard of demonstrating a guaranteed subcontract or something that was essentially certain, and the cause of action just requires that it was more probable, that it was more likely than not, that it was probable, as opposed to just merely possible. And we think there's ample evidence in the record, certainly enough for a jury to decide, to be presented to a jury to decide, including the fact that the General Dynamics corporate representative who was deposed.
But be clear, the district court in this case, as I read it, maybe I'm wrong, but correct me, only relied on that first factor that you didn't establish this factor that the existence of a business expectancy with General Dynamics existed. Is that right?
Your Honor, that's right.
So it turns on that. So what do you have to show there was some sort of business expectancy?
Your Honor, the business expectancy, there's a number of factors, including the fact that that General Dynamics was poised to award this contract to ADNET on a sole source basis. They had already submitted ADNET's pricing to the Army. The Army modified General Dynamics contract to pay those prices, which is a determination that the prices are fair and reasonable. In the General Dynamics corporate representatives.
But that was just a placeholder. I mean, the submitting of the prices to the Army, wasn't it just a placeholder? I mean, what I'm trying to do is determine what is that subjective evidence that ADNET probably would have received this subcontract.
First, Your Honor, the corporate representative testified that this would have been a sole source, but for the appearance of the defendants. When they showed up and said, "Hey, we're also interested," she said that automatically makes it competitive. That was the key. It was their appearance, and then. But I would actually sort of disagree. I don't think it's a placeholder. When in a government contracts, General Dynamics is not going to sign a subcontract with ADNET until the Army covers it first. So they start with the rough order of magnitude, the estimate, they get it added to their prime contract, and then that gives General Dynamics the Army's blessing to award the subcontract. So it wasn't the actual subcontract, but it was more than just a placeholder. It was actually concrete steps showing that General Dynamics was ready to award this to ADNET. They would have. But for their appearance. If there are no more questions.
All right, thank you very much. Let's hear from your opposing number.
Good morning, and may it please the court. My name is Plak Patel, and I represent the appellees Rohit Soni, Laura Barr, and Jason Laird. This appeal involves an uncomplicated question of applying black letter Virginia law that has been clearly decided by the state Supreme Court. As was properly concluded by the district court, this matter cannot be distinguished from Williams v. Dominion Tech Partners. It is established law in the absence of a contract restriction, an employee has a right to make arrangements during their employment to compete with their employer.
There is the distinction of the competitive bidding. And the question then arises, is there a jury question that can come from the fact that unlike in Williams, there was a competitive bidding by employees of the company?
Yes, Your Honor, and I do believe that this distinction leads in favor of the appellees. And the reason being is that in Dominion, ACIYS was an existing client. Whereas in the matter at Barr, GDIT was not an existing client, and the competition allowed ADNET the chance to put in its own proposal. And so both companies were planning on competing. There was no competition yet. And what ADNET glosses over is that it's its own actions that led to it not receiving the contract.
Well, those are all issues that I don't think you can say are uncontested issues of fact. Which is why you're here based on a summary judgment motion.
Your Honor, the district court said that it was undisputed that.
Well, I understand that that's what it said, but I think there can be a fair reading of the record to say that the district court was incorrect on that point. So when you look at the district court's opinion and you compare it to the Virginia Supreme Court's decision in Williams, it leaves me some pause because Williams was very clear that the three circumstances mentioned by the district court with regard to misuse of confidential information, misappropriation of trade secrets, and solicitation of clients was not an exhaustive list. But the language of the district court's opinion seems to indicate that it read it as an exhaustive list, because it says that the only question before the court is whether the defendant solicited plaintiff's clients. And that's not what Williams says.
Your Honor, I think that what the district court was saying, that it's explicitly.
I'm reading the language directly out of its opinion. It says the only question before the court.
And I believe that was part of its consideration in considering the totality of its circumstances.
Now, it doesn't say anything about totality of the circumstances. It says you got 3 questions. I'm only going to consider 1.
And I believe the district court ruled that way because ADNET does not allege that there was a misappropriation of trade secrets or any misuse of confidential information.
Right,
So-
but I understand what you're saying, but Williams and other Virginia cases make it clear that those 3 circumstances are not the only ones by which a breach of fiduciary loyalty claim can be made. So what's your response to the approval by the Virginia Supreme Court of the restatement of agency that deals with these issues?
And I do believe even that the restatements cited by the appellant states that employees are allowed to plan to prospectively compete in the future. And so Williams is not distinct from what the restatements is saying.
Well, what about this in second restatement of agency 393? Employee is not entitled to solicit customers for his rival business before the end of his employment, nor can he properly do other similar acts in direct competition with the employer's business.
And I think that hits the issue right on the head. GDIT was not a current client, nor was it even a prospective client at that
The
point.
restatement doesn't restrict it to current clients. And I don't think there's a Virginia case that restricts it to current clients, unless you know of one.
No, Your Honor, but even if we limit it to prospective clients, that was not the case here. Specifically, ADNET never was only in consideration, but it was never promised the sole source contract from GDIT. GDIT's testimony
Right,
states.
but isn't that the ultimate factual determination to be made on the merits?
And I think the district court properly concluded that a jury would not reasonably find that ADNET was assured anything beyond the mere hope of a contract with GDIT.
Well, there you're bringing in this guarantee business expectancy, which is not an element of a breach of fiduciary loyalty claim under Virginia law. It's an
No,
element of tortious interference, but it's not an element of breach of fiduciary loyalty.
no, Your Honor. And that's why I believe the breach of fiduciary duty claim is quite straightforward, because the loyalty lies in ADNET or in.
Send your response. No, what? No, it's not an element of business fiduciary, this business expectancy, or no, in terms of what how do you explain the no when you said no, Your Honor? I couldn't understand it.
Yes, Your Honor. So what I mean is that while it may not be an element, the elements are showing a duty, showing a breach of those duty and result in damages. But what the expectancy is simply a consideration when the district court was looking at the totality of the circumstances. And so in looking at the totality of the circumstances, there was no
Well,
duty.
Even if we accept that as valid for our argument here, wasn't there evidence from the other side that they had some type of an expectancy?
No, Your Honor. So their testimony solely relies on the testimony of its CEO. And what GDIT has explicitly said, well, there's 2 layers to this. First, the Army has explicitly testified that it had no involvement in who GDIT would have chosen as a subcontractor. And then the second layer of it is that GDIT's testimony, which has been undisputed, is that it did not even know of ADNET until it received the contract from the Army. And then afterwards, it was exploring several options that included keeping the work themselves or having a competitive process where it would choose a subcontractor. And importantly, ADNET and the appellants were not the only companies being considered, GDIT was also considering previous vendors that I had worked with, including C2I
All right,
Technologies.
but they've also got evidence that this was going to be a sole source contract. That there were indications that that was going to be the award. A jury may not find that to be accurate, but when we're here on summary judgment, we have to take the evidence in the light most favorable to the non-prevailing party.
Yes, Your Honor. So I believe that no jury would conclude based off of the evidence that AdNet presented or relies on that this would have been a sole source contract. Opposing counsel did state that
Right.
AdNet
I
submitted
understand that's your position.
Yeah.
But if a jury didn't agree with you and instead they found the opposing party's evidence to be more credible, couldn't they return a verdict?
If they did find the evidence to be more credible, certainly, but the evidence is not credible and directly contradicted by the Army and GDIT because the evidence indicates the record is
Right,
clear.
but isn't that classically what you would argue to the jury
Well,
and let them weigh the evidence?
so in matter of summary judgment, it still is not the district court properly found that a jury would not reasonably find in that favor. As it was, AdNet did submit an initial pricing, and they claimed that this was used in a proposal that GDIT submitted to the Army. But then AdNet subsequently included additional costs that included half of its facility fees. This amounted to another $26,000 a year. So there was no assurance that it would be a sole source contract. Indeed, AdNet was changing its proposal and its pricing. There was no agreement, and GDIT has stated that it still had the option of doing the work itself. So here, I think that the district court correctly found that on Williams is directly on point. It's undisputed that the Army made the decision and informed AdNet that the prime contract would not have been renewed after its termination on August.
Your position would be your position would be different, as I understand it, if the employees had known that AdVet was bidding on a contract, on
My
the General Dynamics contract. Your position would be different if the employees here had known that AdVet was actually bidding on a contract.
No, Your Honor. At that point, it still was. The appellants were still appellees were still justified in bidding for prospective employment, and that's what it was.
But I understand you think your position was stronger, even if your position wouldn't change. You think your position was stronger in light of the fact that the employees here did not know, or that they had no inkling that AdVet was actually bidding on the subcontract.
Certainly, the process was conducted by GDIT.
Is that correct?
Yes, Your Honor. Certainly, the appellees were not aware that AdNet was certainly.
Well, but there's testimony from the executive at AdNet, among others, that they did know that the reason that they were able to bid on it was that they found that out in employee meetings.
There's no evidence in the record that cites to that besides the self-serving testimony of AdNet's CEO. As the appellees have testified.
Well, that it may be self-serving, but that's what you argue to the jury.
Your Honor, the process is clear and the record is undisputed that GDIT held the competition in a manner that isolated the parties and did not allow this information to be shared. Specifically, the parties signed NDAs. And AdNet itself admits that it was keeping the information regarding its bid and the details of its proposal insular. It was not being shared with employees. And so even if our clients had a mere idea that AdNet was submitting a proposal, the substance of it was not known, and it could not have been known by the nature of the competitive process.
I understand you are saying that although there may be a dispute here, that there was no genuine dispute of material fact on the point that the employees did not know that AdVet was bidding on the subcontract, or what the relationship between AdVet and General Dynamics was. Is that correct?
Yes, Your Honor, that explains it correctly. That there's no genuine dispute that our jury would reasonably conclude that especially in light of AdNet's admission that it was withholding the details of this proposal, that the appellees could have known anything beyond the details of its own bid.
So your view is that it's not a breach of fiduciary duty for employees who are looking for work after their employment is scheduled to end. They're looking out for themselves. And if they do not know that their employer is involved with General Dynamics or with any contractor, just in order for employees to be able to look out for themselves and to provide some sort of future opportunities for themselves after they leave their work, that can't, your view is that should not be a breach of fiduciary duty, because you would be really disadvantaging employees from trying to avoid unemployment or being out on the street after they leave their present job. And if there's no genuine dispute that they did not know that Advet was going to be bidding on the subcontract, what they did was what employees do all the time, which is to make some provision for their future.
And I think that hits it exactly on the head. This competition process was essentially AdNet and the appellees submitting resumes. Their proposals were essentially resumes looking for employment. There was no.
Since there's evidence in the record, I'm just importing. It seems like to me, I think I remember seeing something where the CEO of this company said he told them that there was a bidding. And what if there's evidence in the record? There were text messages with the defendants here that basically acknowledge that they believe that AdNet was in the bidding process. Does that move this from a dispute to a genuine dispute?
Your Honor, I think that this is.
I mean, would that type of evidence do that?
No, Your Honor, and I think because Williams does cover this, because in Williams, the employee knew that Dominion, the ACSYS was a customer of Dominion.
Here's the evidence in which the CEO said he told him. That's his evidence. I told him I was in the bidding process. Then there's text messages between the defendants acknowledging, there's they're probably in this bidding. You're saying that a reasonable jury could not discern from that particular evidence to rule in a different way?
So the answer is sort of twofold. That one, the timing of the text messages does apply because these text messages were not exchanged during the process of when the parties were submitting their proposals. These text messages were after the fact. And so at this time, the process had sort of
but if
played
they
out.
evidence their state of mind, why isn't that relevant for a jury?
As the district court properly ruled, the motivation is sort of irrelevant to the elements of a breach of fiduciary duty.
But those questions don't go to that. It's whether or not there's record evidence that there's a dispute as to how your clients came to know and make the bid. And so there is evidence in the record that the CEO testified that he told them. That's how they found out about it. And there are the text messages Judge Wynn referenced. But is there something else in the record that discloses how your clients became aware of the AdNet bid? Or the contract, or how did they know to submit a bid to GDIT?
Your Honor, the record is sort of devoid of any sort of evidence pointed out by AdNet which indicates that the appellees only learned of this opportunity through its employment. I mean, at the end of the day, this does involve a government contract, and there's a certain level of transparency required when contracting.
So did you just say that the record indicates that they learned of it through their employment?
No, the record is devoid of any evidence that is certainly what happened, even though that's what AdNet's position is.
All right, so I don't need to keep going over this, but tell me how that's not a disputed issue of material fact. I mean, if you have no evidence in the record of how your clients became aware of this possibility, and there is evidence, you don't think it's credible, but a jury might disagree that they learned of it solely through their employment, how is that not a material dispute of fact?
And I do believe I do believe that because this consideration was not an issue in Williams, the court is quite clear in Williams that it didn't matter whether Williams found out through his employment or through other means. It was the issue was the fact that Williams was planning for prospective employment. So the court wasn't really considering how it was found out. So it's sort of immaterial how the police found out about this opportunity. Indeed,
All right, now counsel, let me ask you this. To me, it's important as to whether these employees knew that Advent would likely be bidding on the client on the General Dynamics contract or not. Give me your, the other side is indicating, well, that's a jury question. Now you tell me why you don't think there's a genuine dispute, just in plain terms, why you think there's no genuine dispute over the fact that the employees here did not have any idea that Advent was bidding on the subcontract, because there's a danger in going far with this and submitting all of these questions to juries in the absence of a genuine dispute. We are preventing employees from looking out for themselves when their employment, for whatever reason, ends. So a lot of it, in my view, I think competition and competitive bidding is a good thing. I think there are limits to the degree in which, as the district court, we can invoke tort law to shield companies from the competitive bidding process. And these people did not disclose trade secrets or divulge confidential information. But the question I have, it's important, it's a material fact to me. The question is whether there's a genuine dispute. Now just tell me in plain words why you think there is no genuine dispute that the employees here had no idea about the fact that Advent was going to be pursuing and bidding on the General Dynamics contract, okay? Just come to grips with that, because obviously you've got some questions about it. Come to grips with it.
yes, Your Honor. And so I think that the answer is sort of twofold. That at first, no one could have been aware that AdNet was bidding for a subcontract because GDIT itself did not know that the subcontract would exist. It was considering several options, including insourcing the work. And subsequent to it choosing to compete the contract, the police could have no idea because the process was sort of shrouded with secrecy in order to isolate the parties, including NDAs and such. And as AdNet itself has testified, it did not disclose the details of its proposals or what it was likely to do to its employees. At this time, the employees were only aware that the Army contract that it was working on was set to expire August 31st. And it had no expectation and no indication that they would need to continue to work on this project after the fact. And that's what the district court sort of ruled, is that the issue of whether the employees knew or not was it could not have known because of the nature of the contract with GDIT and also the subsequent actions of AdNet during the bidding process.
You say there's a finding to that effect in the district court opinion?
Yes, I believe in the district court's findings of facts, it does rule that the employees had not been communicated that they would need to work beyond the August 31st date.
What's that have to do with whether or not they were aware of the subcontract with GDIT and the opportunity to bid.
And so that leads into the idea that the appellees would have no idea because it was never communicated to them, the idea that AdNet could continue working on this project even as a subcontractor of GDIT.
All right.
All right, thank you very much. If anyone has any further questions, we'll open this up to rebuttal. All right, thank you.
Thank
Mr.
you, Your Honor.
Boland, you have some time for rebuttal.
Thank you, Your Honor. Two quick points. I want to make very clear, the only reason the 3 employees ended their employment relationship with AdNet was because AdNet lost the subcontract. And there's nothing in the record that indicated their employment would end in August. AdNet had every intention to keep their employment going for several more years. That was the goal. Employers don't have an obligation to disclose that to their employees. But I think that there's certainly evidence in the record for a jury to decide, and there's a genuine dispute as to whether or not the employees knew or also just sort of deliberately did not know. There's a whole concept of sort of deliberate, you're sort of burying your head in the sand.
So this is where it's coming down to, questioning whether they actually knew of it. All the things we've seen, we're just talking about, did they know of this contract? There's evidence in the record. The CEO testified that he told them. When did he so-called tell them?
He told them in the spring of 2020 when the Army first told him about this, and
then during, I guess, his deposition, there was a question presented to one of the defendants, Law, and the question essentially was, why didn't you ask AdNet if he had a contract? And he says, at least from what I'm reading here at J250, he says that he was interested in pursuing the contract because the CEO had essentially told him about it. So I'm trying to understand why that doesn't create an issue of fact as to, did they know? It may well be a jury can go one way or the other, but it turns upon the text messages with the defendants, whether it was before, pursuing, or whatever, it's a state of mind. In so many cases in which we are dealing with issues of fact on it, we don't like to make that decision for the jury. The only question is, did you know? And there's a lot in this evidence, this record, that seems to indicate that. What do you say, using Judge Wilkerson's question, is your best evidence to show there's sufficient evidence in this record that would create a genuine dispute of fact that would allow a reasonable jury to conclude otherwise?
Okay, Your Honor, not my only evidence, but the best evidence is sort of outlined on page 11 of our opening brief. The day before the defendants submitted their proposal, not after, the day before, there were text messages, and they specifically mentioned avoiding the CEO so they wouldn't get pulled into General Dynamics work. There was no other General Dynamics work. They were talking about the proposal. They knew exactly what was going on, and they thought it was funny, and they took off for work that week because they didn't want to basically be pulled in and work on AdNet's proposal when they have a competing proposal that they're submitting. They were being deceptive. They knew, and it's certainly at a minimum that is more than enough for a jury to make that call. I would also add, there's another.
What would be your response if they did not know? Let's just assume arguendo that they did not know, because the question is, how broad are we going with this kind of thing, and to what degree are we shutting off an employee's ability to look for employment after, for whatever reason, one leaves the job? So if they did, just assuming arguendo, in response to Judge Wynn's question, that the employees did not know that AdVet was pursuing the General Dynamics contract, what would be your position then?
Your Honor, I would point your attention to the Virginia Supreme Court case in Horn versus Holly. I think that case speaks to the idea, and this is a quote where it is where an employee, not the employer, quote, must make a frank and full disclosure of all material facts in a fiduciary relationship. I think in this context,
what is that? I mean, what I'm worried about is writing too broadly here, and signing off on some general proposition that employees have no right during employment to to seek opportunities after employment that may incidentally bring them into some kind of competition with the employer. Because if you're working for an employer, you have certain kinds of skills, and it's quite likely that post-employment is going to require the utilization of those skills. So there may be a lot of incidental competition with an employer, just because they're in the same field. Now you can approach this question broadly and say, oh no, you have no right doing employment if it's likely to involve the same line of business or potential competition or just conceivable competition with the employer. That seems to me to slam the door pretty darn hard on both employees' rights and the desires of the competitive marketplace, which is the district court held, which it can shield people from competition. And so I want to know specifically, there's a way, the way to have this narrow and say, if you knew of the specific contract with this specific party, if you came upon that knowledge indisputably, that's one thing. But if you did not know about it and you just happened to stumble into a competitive relationship, that's another thing. So what I'm asking you is, again, if they had no idea that that was pursuing or bidding or whatever the relationship with General Dynamics, would your position still be the same? And wouldn't that be awfully broad? You don't need to go that far, do you?
Yeah, Your Honor,
you don't need to go that far. Excuse me, counsel, all you need to say is that there's a genuine dispute here, that they knew about this contract from the CEO and everything, and they competed about something that they absolutely knew the employer of a line of business with a particular party that the employer was pursuing. We don't need to go into these broader general propositions about when employees can generally look for post-employment opportunities. I see there's a narrow road that you have, and there's a broad road that you have.
Your Honor, I would agree, and I would say that in this instance, the answer is this was a very specific Army medical research development database. It was a very specific work. We are not saying that the defendants could not go seek work doing generic web development with thousands of job opportunities around the country. This was a very, very specific work, and it was a separate agency.
But that's important, isn't it? It's important, isn't it, to ground the disposition in the specific facts of this contract, this party, and the knowledge of these employees of the specifics, right?
That's right.
That's the jury question. Okay.
Yes. Yeah.
Okay. You're not asking us to bite off any big chunks.
No, Your Honor. I think that's right.
All right. All right, we thank you very much. If there are any further questions from my colleagues, I'd be, we would be happy to let you answer them.
No questions.
No questions, Jim.
Okay, thank you very much. We appreciate both of your arguments, and we will go now into the
Judge Wilkinson,
end of the third.
Judge Wilkinson, can we take a very short recess?
Well, of course, absolutely, sure. We'll take a 5-minute recess. Is that okay?
Yes, sir. Thank you.
Yeah, that's fine. William Bid versus the Charlotte Mecklenburg School System. And we are pleased to hear from you, Espelade. We're happy to hear from you.
Thank you, Your Honor. May it please the court, my name is Kelly Espelade. I'm here today to argue why the administrative hearing officer's findings are not entitled to deference. I ask the court today to reverse the district court's decision and make a decision on this matter, or in the alternate, remand with instructions. Specifically, I ask that this court rule that the district court erred when it found there was no genuine dispute over a material fact. The district court erred when it ruled that the ALJ's final decision was entitled to deference, and that the district court erred when finding the ALJ's remedy was appropriate. The issues I'm going to address today are whether summary judgment was proper when there was a genuine dispute of material facts, and whether the district court erred as a matter of law when it ruled that the administrative law judge's final decision was entitled deference when the decision was not regularly made. Under the IDA, fact-finding is critical, as many of the legal issues resolve around questions of fact. Because the ALJs are charged via their fact-finding duties with determinations that go to the very heart of the substantive rights of children with disabilities under the IDEA, it's imperative that ALJs write decisions that make findings of fact on all of the facts relevant to the legal issues presented at the administrative hearing. The Fourth Circuit views questions as to the appropriateness of a child's IEP as questions of fact. That's out of GV Fort Bragg. The standards that we look at is Board of Education v. Raleigh, which addresses the proper role for a district court reviewing a state administrative decision in an IDEA case.
Let me ask you a question regarding the regularly made. It was a hearing process. There were fact-finding norms, but I take it your biggest problem, or a major problem you have, is that this is rather lacking in detail. It's rather brief, and you think that should be a basis for saying it was not regularly made?
So that's right, Your Honor. We do believe that there is a case that's pretty much on point here, and that's JP. And in JP, it clarifies what constitutes a regularly made decision. In that case, following a hearing in which a witness testimony and evidence was presented by both sides, the hearing officer issued a 25-page written opinion that 1, summarized witness testimony, 2, outlined applicable legal standards, and 3, presented the hearing officer's findings of facts and conclusions and legal
What about the
conclusions.
standard, JP?
I'm sorry, Your Honor, can you repeat that?
Well, as I read that case, I'll quote directly from it. Our case law suggests that the level of detail required of a hearing officer is relatively low. So is this too low in your view? And if so, why?
So, Your Honor, you are correct there. I do believe this is too low in the fact that this case presents with lots of cursory and conclusory statements throughout it, as well as the findings of facts in this case did not even speak to some of the legal issues that were raised, to some of the issues that were raised, specifically related services. This case never spoke, the findings of facts never even spoke to that, and that was an issue that was raised throughout the court. I do find that the findings—
With regard to because this I assume would relate directly to the deference by the district court to the ALJ's finding. If I'm remembering this correctly, other than credibility determinations, the district court did its own analysis of the record and did not defer on most of the issues to the findings of the ALJ, but made its own and stated its own.
Your Honor, I don't believe that the district court stated its own, because it ruled on a summary judgment motion where it looked at the findings of facts. And if you look at the ALJ's order, I'm not sure that you can make a connection between the legal issues and the findings of facts and how the judge came to that conclusion. The only ones that I do think that she even spoke to—
The district court has got the record, and if I'm not confusing this with another case, the parties chose not to introduce any additional evidence, which they could do if they wished.
That's correct, Your Honor, but I do want to point out that in the district court's order, one of the parts that the district court also leaves out is related services. They don't speak to it. And so while they even have the record, there was nothing remotely in their order that spoke to related services, which tells me that if a de novo review was done under the district court, their ruling would have spoken to these related services.
I've sat on a lot of these cases, and it seemed to me that the ALJ did a lot of things right. We've made a point in our cases of saying that the ALJ's findings must be decent, but they don't need to be perfect. And it was ALJ had a 10-day hearing, witnesses and exhibits. The actual findings of the ALJ were found in favor of you on 2 issues, and ALJ listed the witnesses it found credible, and those it did not. It made detailed findings of fact on a number of issues. If the ALJ had just given this the back of the hand, that would be one thing. But it seemed that as these ALJ hearings and findings go, this is on the more thorough end of the spectrum. As I say, a 10-day hearing, that's no brush off on the back of the hand, and giving everybody a chance to present their witnesses and their exhibits, detailed findings of witness credibility. As Judge Agee points out, the standard here is relatively low, and the one mistake that was made here, which is a failure to set goals and criteria to the IEP team, which is what a lot of courts have done, because the IEP team is the one that's going to have the best view of the situation. They put a lot of time into it. But I guess my overall treatment is inadequate. Then there is nothing we can't pick apart. And we're asking for a standard of perfection that our cases don't require. And I can pick apart any of these hearings to say, oh, well, this little issue wasn't found, or this, or what have you. But there has to be a limit to this. We cannot run the Charlottesville-Mecklenburg school system from the bench. That's not our job. But all I'm saying is that in the spectrum of these hearings, the ALJ didn't do a perfect job, but the job that she did was doggone good. I know you don't agree with that, but given the time that was devoted to it, and the list of the credibility findings, and the fact that she was balanced and found for you on 2 issues, I mean, what do we expect from people? We're applying standards to these folks that, if they applied to us, we'd be making an error in everything we did.
So, Your Honor, to respond to that, while we don't contest that the court hearing was held appropriately. We do contest and state that when we're talking about regularly made, the judge in this particular case did not include findings of facts on all issues. She only addressed 2 issues that were brought about in the case. Those being the ones that she actually ruled in our favor were issue 1 and 2. And she gave enough detail to show that findings issue 1 and 2 were supported, specifically in her discussion where she notes that her own on the record comments concerning this issue at JA 383. Further than issue 1 and 2, I can support issue 1, finding fact 4, 5, 7, 8, and 9 all lent to that issue. So she does support issue 1 and 2 specifically in her comments as well. The problem is the rest of the issues are not supported by findings of facts.
Well, you were starting to make an argument about the related services issue. Why don't you use that as an example and tell us what the problem is?
Okay. Your Honor, so that's correct. So part of this case spoke about speech, occupational therapy, related services for the individual. And that related service is not spoken about in her order. There is 0 findings of facts as it relates to.
Well, the district court addressed it specifically. JA 676 and 677. In some detail.
Your Honor, the only thing I would say is not only do we have a related service issue, when she weighs credibility of witness, she doesn't elaborate on it. There's no elaboration on witnesses of credibility. Not on top of that, she incorrectly names the witnesses. She names a witness of ours.
Do we require explanations of credibility findings?
Your
There- Counsel, I've been, we review credibility findings all the time. We don't require explanations of every credibility finding. And so, oh, well, this person's body language was this, and this person's facial expression was this. The overall question, I thought your case had been given the back of the hand, but I just don't see that. Even when you get to the district court level, he's having a 2-hour hearing on the summary judgment motion hearing. The ALJ's findings, they're pretty doggone thorough. I mean, if this doesn't pass muster, we have set an impossible standard, and that's not where the case law goes.
So while the court sees them as fair, we would argue that they're cursory and conclusory. And there is case law to say that if they are cursory and conclusory, they shouldn't be given deference. And so on appeal, courts must reject
What about
facts.
the related services? That there wasn't any deference there because the district court did it on its own. What's wrong with that?
So if the district court looked at related services, then I would argue though that still the ALJ's order in a whole was cursory and conclusory.
Right, but under the way we review these, I mean, it was a de novo review by the district court. The district court spent 2 pages on it, laid it out in some detail. You haven't told us what the error is here. You haven't, I don't recall anything in your brief that says the district court was wrong on this for reason 1, 2, or 3.
So, Your Honor, I mean, I guess we would argue that if a de novo review was done, the statements from the district court would include a large amount of findings of facts over a 10-day period. There was a large record in this case. And I don't think that was completed here. So I don't know how much of a de novo review was actually completed. That it still stands as our argument. As far as also the remedy issue, we have a remedy issue here. We are literally sending a remedy back to the wrongdoers. The crux of this case was the
So
least.
what do you say the district court should have done? That would seem to be pretty much the linchpin of your argument on this point. So I hope you have an answer.
So, I would think that the district court would have had to address remedy and given an answer to remedy.
Did you tell the district court what you wanted for remedy?
I believe that we at least spoke to that we did not think it was appropriate for the school to make the remedy, and that the remedy obviously needed to be least restrictive
So you
environment.
wanted the district court to make a remedy, but you as the proponent didn't offer to the district court a remedy for it to consider?
Your Honor, I do believe we offered a remedy, and that remedy was that the court needed to decide where the least restrictive environment was. There was testimony as to what was appropriate for the student, and we needed the court to remedy the issue because the issue that we had at hand has not been remedied. It was sent back to the school.
What's wrong, counsel? What's wrong with sending it back to the IEP team? This is done all the time, and it's done for a good and sufficient reason, and that is the IEP team has spent loads and loads of time with this individual's case, and the district court's familiarity, such as it is pretty good, but it's not perfect. I mean, it doesn't approach the IEP team. And the IEP team, for example, includes the plaintiff and the plaintiff's mother, which it certainly should. It's just up to the IEP team to address the missing criteria. But that's standard stuff. That's just nothing unusual about that.
Your Honor, I would disagree with that. If the way an IEP is set up is that the LEA, who is a school employee official, has the final say. By giving the wrongdoer it back and them having the final say, we are leaving least restrictive environment up to the school to decide. So if we get back to an IEP and we disagree again, it now creates a revolving door. We'll be right back at court on the same issue that the court did not answer or address when we initially brought it to the court.
Right, but you didn't tell the district court, here's the remedy we want. Or if you did, you can show us where you did. They need to go to this school, take these courses, have this sort of therapy. It just seems like to me, you're saying the district court was wrong, but we're not going to tell you what it should have done right.
So, Your Honor, why I cannot speak specifically if we wrote it exactly to the district court. It was in the initial petition when we requested what we were asking the ALJ to order at that point.
You're going to have some rebuttal time. Maybe you can look it up and tell us about it. Fine.
All right, thank you.
Your Honor.
Ms. Leonard, we'd be pleased to hear from you.
Thank you, and good morning, Your Honors and Counsel. Ashley Leonard with Campbell Shatley on behalf of Charlotte-Mecklenburg Schools Board of Education, and may it please the court. There are two issues before this court, and both should be affirmed. First, the administrative process in this matter was exactly how the process should happen. And second, the ALJ ordered an appropriate remedy as part of that regular process. Regarding the first issue, the parent's argument boils down to whether the findings of fact in the ALJ's decision were essentially long enough. The district court in this case followed this court's reasoning in Doyle v. Arlington County School Board, which reasoned that reviewing courts and deciding what weight to give an administrative decision should examine the way in which that decision it should examine the way in which the administrative agency arrived at that decision and the methods employed. Here, as you know, there was a 10-day administrative hearing, non-consecutive days from January through March 2018. It was very much like a civil trial.
I think
where the-
admitted it. Opinion here is rather short shrift. But if I'm taking your argument as to where it seems like it's going, is that you look at this holistically in terms of all that was done. The examination of witnesses and et cetera. I guess the question becomes up is what is our review? And when we're looking at what the actual opinion is, it is pretty direct and curt. It seems, at least some of the issues seem to be, there's not much there. And it wouldn't have taken much to do it. Let me ask you this. A lot of times on these cases, because of the trial judge brought it up, these ALJs are really overworked. There's a lot of work to be done. So they are trying to do this. And so is it a practice in that particular jurisdiction for the council to hand up a proposed order or, you know, put this forth? I mean, because there's a lot of work to do it. It's all there. And the question is, did this ALJ do enough? And you're saying when it comes on appeal, we can't just look at the opinion, but look at all the other stuff. Is that the practice within this jurisdiction or not?
Yes, Your Honor, it is the practice within the Fourth Circuit to look at the process as a whole.
No, I mean practice within this jurisdiction in the Charlotte area when the ALJ renders a decision or anywhere or to hand up an order, a proposed order that would sort of lay it out. The ALJ then can sort of track it if they want by the prevailing party. Or
Yes.
I guess you could ask both.
Yes, Your Honor. In North Carolina in particular, ALJs do ask both parties to submit proposed orders. The ALJ did that in this case as well in
So
March
this is the order that
2018.
was put up by you, I guess, or this is actually, how much does it track that order, that draft order that was there? Did you, was there an order that was put forth and then ALJ didn't redacted it to be nothing? Or was there one that had a lot more into it? Let's put it.
The ALJ's final decision actually tracked the parents' proposed order more than CMS's proposed order. Both proposed orders from both parties were not substantially longer than the ALJ's final decision. The parents
So
proposed.
are you representing that this order looks a lot like the proposed order that was put up by the parents?
Yes, Your Honor.
Of course, that's not in the record what the actual proposed orders, but I mean, let's deal with reality here because of just the sheer workload here. And Judge Wilkerson points out rightly, I mean, we want to be able to try to not overburden, but at the same time, when it becomes the reality that, you know, the parties are allowed to submit a proposed order. And I guess I'm trying to understand, how does this final order compare with what was proposed in the process when we are confronted with the question of whether enough was done in order to be able to set it forth? But you wouldn't expect the parents to be able to give the reasoning behind why the ALJ operated in a particular way. You would expect that more to come from the party that prevailed, wouldn't you?
Yes, Your Honor. It was very clear at this administrative hearing that the issue of the student being in the separate school was of central importance to the ALJ. And that is the sections from the parents' proposed order that the ALJ's final decision reflects.
That's because the ALJ determined that that was not the least restrictive alternative, or that there were no criteria by which to judge whether it was the least restrictive.
Yes, there was no criteria to judge how the student would exit that placement. There was no finding that the placement at the public separate school was substantively inappropriate, just
Let
that
me
there
ask
was
you
a
on that,
lack.
and I think I'll probably turn loose because I'm trying to understand. This is a sensitive thing. I mean, when you look at it, I think the IEP and the groups are doing, I think you're doing the best, and it's a very sensitive situation in which you've got the student and the federal law mandates certain things because of the money you're getting. And ultimately here, there was she initially was in a situation where she's in with students who are not, in a disabled situation or not. And then this decision is made that has to be in a separate, because of the behavioral situation, has to be in a separate situation. So what do you view the parents asking for now? To be put back where she was, or to be put somewhere different? I mean, what is it that they, in light of all that's here? I mean, that's pretty clear why she was put here, but what do you view them as asking?
So in both the parent's original administrative due process petition and in parent's federal complaint, in those separate requests for relief, the parent requests exactly what the ALJ has already ordered. In both of those requests for relief, the parent requested an order for CMS to convene an IEP team and develop an appropriate IEP.
Is that the remedy that I was asking opposing counsel to find?
Yes, Your Honor. And that is exactly what the ALJ ordered. It is such a common equitable remedy that parent requested it in both the administrative agency and with the federal court.
So as the result, they're not happy with, not the remedy, I guess. What is it? Where's the unhappiness from your view? I understand their articulation.
The parent made multiple requests in their request for relief at the administrative hearing. In addition to asking for an order for CMS to develop an appropriate IEP, they also requested either private school placement or placement at a regular CMS high school. If the ALJ had found that the placement at the public separate school was inappropriate, she could have ordered that relief. But she did not find that the placement at the public separate school was inappropriate, just that there needed to be criteria within the IEP to know when the student could leave that public separate school. Regarding JP, CMS also believes JP is controlling in this case with respect to the findings of fact. The ALJ's administrative decision in this case is more detailed than the administrative decision in JP. In JP, the hearing officer found all witnesses had credibility. In this case, the ALJ was specific with who she found more credible on all issues. She found 4 of CMS's 6 witnesses more credible and 1 of parents' 9 witnesses more credible. And that shows she took careful consideration of credibility and persuasiveness into account. In JP also, the administrative decision offered no explanation for why the hearing officer in that case found the school district's evidence more credible or persuasive. None of those deficiencies were sufficient for the Fourth Circuit to determine that that administrative decision was due the deference that it was owed. And in this case, there were multiple findings with respect to multiple contested issues. Regarding
one thing, counsel, one thing I would suggest, and we've been a number of cases where we've actually upheld ALJ findings that were, and I can only say, after reviewing the process and the findings and the care taken by the ALJ and the care taken by the district court, I only wish that in most cases the process had been this good. Does that mean it's perfect? Does that mean it can't be picked apart? No. But I only wish that most hearings dealing with this very important legislation, I only wish they had been this good.
Thank you, Your Honor, and I agree. With respect to issue 3, the final administrative decision, the findings of fact 2, 8 and 9, 14 and 16 address issue 3. With respect to issue 4, fact 5.
Just when you're going through these, just tell us real quickly which, instead of using the number, what the issue was.
Sure. So issue 3 is about whether CMS developed and implemented appropriate behavior interventions. Issue 4 was whether CMS developed appropriate IEPs during the 16-17 school year, except as to least restrictive environment, and facts 5, 14, and 16 address that issue. Issue 5 with respect to related services, as you have noted and as explained at the district court, there was not an implicit finding with respect to related services, but there were ultimate findings on witness credibility and an ultimate finding on the issue itself. And those are facts 14 and 16. With respect to the issue about whether the parent meaningfully participated in IEP meetings and whether CMS predetermined placement, stipulated fact 24, fact 6, 10, and 14 address that issue. And the last issue regarding whether CMS was not required to provide independent educational evaluations, stipulated facts 10 through 16, 18 through 20, and fact 14 and fact 16 address that issue. I also want to point out the North Carolina Administrative Code specifically states it is within the ALJ's discretion whether to include a memorandum giving reasons for findings of fact and conclusions of law. The district court's order in this case also cites to record evidence, not the ALJ final decision in its almost 4 pages of facts. The district court did not simply rely on the ALJ's decision. The parents' 2 issues on appeal with this court are covered in 3.5 pages of the 27 pages of the district court's order. 14 pages of the district court's order are dedicated to the substantive FAPE issues presented at the summary judgment hearing. And again, the district court's order cites to administrative record evidence and does not rely on the ALJ's decision. Due to the carefulness and consideration of the district court's de novo review, the district court's order granting CMS summary judgment and dismissing the parent's complaint should not be disturbed on appeal. Regarding the second issue on appeal with the remedy, an administrative hearing officer has authority to grant relief as the hearing officer determines appropriate. And as discussed today, the hearing officer did not find the more restrictive current placement was substantively inappropriate, but that lack of criteria needed to be in there for a return to a lesser restrictive placement. Once the ALJ determined that the IEP developed for that particular school year was deficient for that lack of criteria, the ALJ appropriately ordered the IEP team to convene to add that criteria. CMS was not at liberty to ignore the ALJ's order, and there is no evidence in the record of any subsequent disagreement amongst the IEP team regarding the ALJ's ordered remedy. This court has approved of a similar result in Morgan v. Greenbrier County Board of Education, holding that there was no error when the administrative hearing officer concluded that a student's IEP was inappropriate, and in lieu of ordering a different placement, which is what the Greenbrier parents had requested, the ALJ directed the IEP team to meet and prepare an appropriate IEP. The parents' position on this issue would create an unworkable legal standard under which ALJs and district court judges will have to draft compliant portions of IEPs in response to any finding that the existing IEP is faulty, oftentimes months or years after the contested IEP is before them. Such a position is directly contrary to the Supreme Court's Rowley and Andrew F. warnings and this court's precedent to not substitute a judge's own notions of sound educational policy for those of school authorities. CMS requests this court affirm the district court's order on the parties' motions for summary judgment because the ALJ's decision in this case was regularly made and entitled to deference, and the ALJ's ordered remedy at the administrative stage was within her discretion and appropriate. Those are my prepared remarks. I'm happy to answer any questions.
I have one maybe question, comment in terms of the case. And I think Judge Wilkerson has postured it somewhat correctly. There's a lot that was done in this case, the hearings and all that's going on. But ultimately, this opinion that was issued is pretty, as the district court says, lack in detail. This is short shrift. And but the district court says, the ALJs operate on a tight time constraints. They can't be expected to issue opinions like district court judges. Fair enough. But you told me that the parties actually hand up draft opinions, draft orders, not required, but in this instance, this was a practice. And so I would suggest, because of the sensitivity of a case like this, that's dealing with young children and parents who are doing their level best to ensure this child that has a genetic situation, she didn't cause it to happen. None of them caused it to happen. Very sensitive situation. She wants her child to get the best education possible with this disability. That when that opinion comes out, I think it needs to reflect some detail more than, well, that's just the way it is, sort of thing in it. And while I agree, there's not much constraint, there's time constraints on the ALJ, I do think that it is important that as the parties, when you are handing up these orders, draft orders, ALJ may agree with it or not, but give them something to work with that they can fashion out an opinion that will give at least, maybe not comfort, but at least some good explanation why it's done. Because they don't remember the witness. They don't remember that. All they know is they see this opinion. And it's like, well, it's like sometimes the judge said, your case is denied. Doesn't say another word. Lawyers can handle that. We understand that. But when you're dealing with everyday citizens and the sensitivity and emotion there, I think there ought to be more in that opinion. I'm not saying it's at the point of reversible here, but I'm saying that. And maybe that's something I don't want you to leave with the feeling that we bless this process and that now we're going to see these little short opinions with not much details because you did all the other stuff, because this is pretty high emotional stuff here. And I think that requires, I hope you will follow me on this in terms of future conduct is what I'm trying to say, that will inform. It might keep this out of our courtroom too, in terms of the future. Thank you.
I appreciate that, Your Honor.
Are there any further questions?
No questions.
None, Your Honor.
All right, thank you very much, counsel. We'll turn back over to rebuttal.
Your Honor, so the question did we ask the court, the best that I could find, as my internet's working lovely over here, is starting at JA 98 to 101. That is actually our prayer for relief in the initial complaint that was filed under the ALJ. Nowhere in there do we simply ask for an IEP meeting. And I think it's relevant that the court understands that a parent can ask for an IEP meeting.
Say that was 98.
98 to 101.
That's part of your complaint in the district court.
That's correct, Your Honor. And I do think it's relevant to understand this court to understand that a parent has a right to ask for an IEP meeting if they want to every day of the week. So to go to court and go through 10 days of litigation to just be requesting an IEP meeting would not really be a good idea for any client to do that. I know there's an argument on 45 days and a timeline to that. 45 days is statutorily set. We do hand up orders to these judges, and our orders are very detailed when we bring them to present to the judge. This judge in particular seems to have taken parts of our order because she found for issues 1 and 2, but where we think she failed is for the other issues, whether it was because she didn't find in our favor or whatever it may have been. We just think that she really does not address them. I know that she just argued that there are points that the court did address, and she went through the findings of facts and the numbers that they correlated to. However, Your Honor, I did go back and review that, and what I found was give me one second. What I actually found was that many of those issues, so the school states that the ALJ did make findings of facts with respect to issue 3, and they cited to fact 8, 9, and 16. 16 in of itself is a conclusion of law. It's not even a finding of fact. As well as 8 speaks to behavior and not least restrictive. And 9, while it speaks to least restrictive, it doesn't address the third issue at hand. The school then argues that issue 4 was addressed. And again, fact 5 talks about least restrictive, and 16 is a conclusion of law. Then they say issue 16 was met. 10 does not, by saying that the facts were 10 and 16. 10 does not speak to parental participation, which was what
Counsel,
issue
let me
6
take you-
was.
Take you back for just a moment. So I've looked through those pages of the appendix that you recited, and the district court's relief for you on the first 2 issues was for the establishment of a framework or criteria to determine going forward what's the least restrictive alternative for the student. So that would be the remedy. But I'm not seeing anything in your prayer for relief that where you tell the district court how to arrange that.
So in our prayer for relief, I believe we asked for private placement because we feel that that would have been an appropriate remedy. However, that was not given to us.
Right, but the relief that you got was determine criteria so we know what the benchmarks are to determine the least restrictive environment. That's the remedy you got. So it seems like that if you say that remedy is inadequate, you would have needed to tell the district court how it was to come up with that framework, make that determination. And that's what I'm not seeing in the.
And I would agree that I believe we did not speak to that.
Okay.
I do feel like, as we stated earlier, the remedy being given back to the school causes a bigger issue since we couldn't agree on it in the first place. I'd also like to bring to the court's attention that when the court, that no deference to a decision that doesn't address critical issues is to be given. And I think it's clear in this case, there's a lot of critical issues that weren't addressed. There were 7 issues raised, and it's our argument that really only 2 were addressed at a very bare minimum. When we look at things regularly made, I think the court really needs to look to JP's case. JP is very similar to our case, but in JP, they did much more. They summarized the witness testimony. Although it was very short, they also outlined the legal applicable standards, and they found findings of facts and legal conclusions. The only clue here, when she spoke about witness credibility, was that one set of witnesses was more credible than the other in this matter. We would argue as a vague reference to credibility. It doesn't really speak to why she came to that finding.
All right, thank you. Thank you very much, counsel. We'll ask my colleagues if they have not, we'll move into our last case. Judge Agee, do you have any further?
No questions.
Thank you, Your Honor.
Judge Wynn, do you have
Do you
have any further questions?
I have no further questions.
Thank you, Your Honor.
We thank you very much. We'll move into our final case.
Thank
We'd
you,
be
Judge
pleased to hear.
Thank you, Judge Wilkinson, and may it please the court. In 2004, 17 years into his sentence, the South Carolina Department of Probation, Parole, and Pardon Services stripped Mr. Torrance of his parole eligibility based on a 1979 armed robbery conviction that it deemed violent. We seem to agree as to the stakes. The department concedes in its response brief that, quote, parole eligibility is a state-created liberty interest that implicates due process if it is denied, end quote. And that is clear under both South Carolina Supreme Court precedent, Furtick v. the department, and United States Supreme Court precedent, Greenholz v. Inmates of Nebraska.
Let me ask you a preliminary question. I don't think you guys even briefed it, but which is always dangerous. But jurisdiction here. Is the vesting of a new claim such that, is there a vesting of a new claim such that your client, Terrence Torrance, could not raise it in a Rule 60B motion to reopen? So a jurisdictional perspective.
Thank you, Judge Wynn. And I want to be sure that I answer and understand that question. I believe that Mr. Torrance's claim arises beginning in 2004 when he received the parole board's determination. He has litigated that claim for the past 18 years, but his parole eligibility actually vested when the 1993 Crime Classification Act took effect in 1994. Now, he did pursue state court remedies and exhausted those before filing his, reopening his federal habeas petition.
So
in this case.
when did he pursue the state court remedies?
He pursued the state court remedies immediately after receiving the department's denial letter in 2004. He filed an administrative appeal later that same year, and then filed a petition for post-conviction relief, which he pursued all the way to the South Carolina Supreme Court and received his order and remitted her in 2018.
So the error, as I understand it, is that you believe that the parole board in the South Carolina courts incorrectly interpreted the South Carolina statute.
Yes, Judge Agee, if they did interpret the South Carolina statute, I would respectfully submit that the error is more fundamental than that. It does not appear that
What's the proof in the record that that issue was raised in the South Carolina appellate courts?
I would point in particular to Judge Keasley's opinion, and excuse me, in the PCR case in which Judge Keasley quite clearly understands and outlines Mr. Torrance's savings clause argument, admits that it seems difficult and caused him to do research, but that he states at one point that he would need more information. It's really unclear to counsel what further information he could have that was not before this court now.
That's a PCR claim in the South Carolina Circuit trial court.
Yes, Judge Agee.
So the point is, your client makes a claim and he takes it on up the ladder, the appellate ladder in South Carolina. So my question goes to, where in the record do we find that the claim you're bringing now about South Carolina law was raised in any of the South Carolina appellate courts?
I would also point to my client's memorandum of law, which is in the joint appendix and was accepted by the post-conviction relief court. And I'm not sure that this directly answers your question, but I believe it's related to what you're asking. So let me see if I can go here. Mr. Torrance, throughout the state court proceedings, was not asserting simply what I would call a state law claim, right? Of this law applies to me and you're not applying it to me. The entire time he recognized that he was actually being deprived of a federal constitutional right. and raised and preserved those claims
But that
as
right,
14th Amendment.
whatever it may be, had to have been given to him through the South Carolina statute. Correct.
Yes, that's correct. And there are two provisions in the 1993 Act that I suggest both save and vest his right to parole eligibility by rendering his 1979 armed robbery conviction as nonviolent. And those two provisions, the first is Section 8 of that Act, under which, and I believe that we agree as to this point.
Well, help me out. I started you out on jurisdiction issue because I'm thinking it's maybe a new claim, but this business of it arising under state law seems to be a separate issue. I don't know if you went on that because it seems clear there's not a habeas remedy for a violation of state law. But do you disagree with that?
I understand that position, but disagree with it and would ask that this
In
court.
other words, it seems to be the law that you don't. I mean, there's a case from this court that pretty much says that remedy, we don't give remedies for violations of state law.
So sometimes violations of state law strip individuals of protected liberty or property interests, and that gives rise to a federal constitutional
Right.
violation.
But you could make that same point with respect to any state statute. I don't see the limiting principle in what you just said. In other words, let me put it this way: in order to decide your due process claim, you have to answer the state law question. The state law question is antecedent to any due process claim. That's got to be front and center. And you say, well, the state law may deprive someone of liberty or property interest. Well, you could just throw that same thing up, that same complaint up to any state statute anywhere and create a federal question out of it. I don't think the Supreme Court has gone nearly that far. And the one thing, doesn't federal law enter the parole process procedurally? In other words, you take a case like Morrissey v. Brewer, and you have a revocation of parole. The revocation of parole has to be in accordance with federal due process principles. But that's due process, and the word process connotes an emphasis upon procedure. But here, this isn't, what is posed to us is not a procedural question which would fit more comfortably into a due process mode. What is posed to us is the meaning of a state statute, which is rather complicated. And why shouldn't that be left to the state courts? Because we can't really address the due process question until we know the meaning of the state law, and we're not the ones to do that. And in fact, the jurisdictional statute clearly indicates that habeas is reserved for clearly prevented federal questions. So isn't your position a recipe for getting in trouble with the Supreme Court?
If I may, Judge Volk,
Pushing us into the interpretation of state substantive law on parole eligibility. How many cases would come to us on that? Hundreds.
Respectfully, Your Honor, and I understand and respect Your Honor's jurisprudence as well on the principle of comity, and I do believe that that is important. Let me outline some distinctions that I think make Mr. Torrance's claim different and don't essentially open the doors to all state law claims coming to federal court. First, Mr. Torrance raises and preserves a pure parole eligibility claim. He is not nitpicking a parole related procedure guidelines application like we see in Swarthout v. Cook.
His parole eligibility depends on what the South Carolina statute means.
Yes, Your Honor.
Right? So it seems like to me you have two problems in this case. One, as I alluded to earlier, I don't see in the record that this particular issue, what does the statute mean, was taken through the South Carolina appellate courts. But even if we assume that it was, as Judge Wilkinson indicated, you have the state law question as an antecedent to any type of federal proceeding. But in this case, it would seem to be even clearer. As I read them, there are two decisions from the South Carolina Supreme Court, Phillips v. State and Sullivan v. State, that address what the statute means. And they say it applies only prospectively and would not apply to your client at all. So in that circumstance, what authority does a federal court have to determine there's a federal right based on a state statute that the state's highest court has said doesn't apply as a matter of state law?
I'll begin with Phillips and Sullivan cases, if I may. And I do respectfully disagree with that interpretation of those cases. Those claims were raised as ex post facto violations by pro se petitioners. There is nothing in the record to suggest that those individuals argued the savings clause issue. The South Carolina Supreme Court in neither case acknowledges the existence of Section 266 of the 1993 Crime Classification Act. And in fact,
they say the statute applies prospective. The only thing that they stepped back from was, well, we're not sure how it applies during that 1 year period or 2 year period while the statute was in effect before it was repealed. But they say, I think in both cases, that it has to apply prospectively. So if the South Carolina Supreme Court has said that, how can we as a federal court say, no, you're wrong as a matter of state law, and therefore we give your client a claim?
I believe that those cases can be read as interpreting to a certain extent, although I will note the Phillips footnote explicitly states it's not interpreting Section 16160B, but they're acknowledging subsections B was added to the Violent Offenses Act in 1993, effective 1994. What neither of those cases addresses or acknowledges is Section 266 of the same act, which states that Section 16160B applies retroactively, other provisions apply prospectively, and all rights and pending and liabilities existing, acquired, incurred at the time this act takes effect are saved. I do want to be sure that I address both of your points regarding the potentially antecedent state law question. I recognize that this case puts this court in an uncomfortable position. The South Carolina courts could have addressed the savings clause and adjudicated Mr. Torrance's claim years ago. They did not. And I would submit that this case is more akin to what it would look like if a state were to establish a parole scheme, but not follow it.
That goes back to the first point I said that gave you a problem. If there was a failure in South Carolina appellate courts to raise the issue, what in the record proves that you ever told the courts that?
So, and Judge Agee, I would point this court to my client's memorandum of law, which is quite impressive for a pro se litigant, and was accepted by the PCR court, and also to Judge Keesley's opinion itself, which clearly outlines Mr. Torrance's claim pertaining to.
I understand his claim, but that doesn't prove anything. I mean, you would have to have some order or decision from the South Carolina Court of Appeals or the South Carolina Supreme Court that shows you brought this issue.
Yes, and maybe
I don't think you have that.
perhaps I'm not being clear. I believe that Judge Keesley's order does demonstrate that Mr. Torrance brought and raised the issue. That is how the court was made aware of the issue. And the judge goes so far as to discuss.
Does that mean that the judge is acknowledging, yes, you brought it in the PCR court, but how can the judge find as fact that this issue was brought in the South Carolina appellate courts if you have no record evidence of it?
Okay, I believe I'm understanding better what you're asking. So because Mr. Torrance's claim did not arise until long after his any direct appeal and even his first PCR, it didn't arise until after he received the department's determination in 2004. He had already proceeded in state court on trial related allegations
All
of.
right, well, no, counsel, no matter when it applied, the fundamental problem that I have here is eligibility for parole, as opposed to some revocation of parole or something, but basic eligibility for parole. Those criteria are matters of state law, and whether the state courts interpret the statute strictly as saying no eligibility, or whether they interpret it more leniently and saying, yes, there is eligibility. The basic question of eligibility for parole is a question of state law. And there's a real jurisdictional problem there, because you cannot, it's too open-ended to say, well, this state criteria, there are millions of state criteria for who's eligible, for who's not, for this and that. And if we start getting into the question of saying, well, no, these particular criteria of eligibility are wrong, or these new field, those are, regardless of whether they are strict or more lenient, the fact is they remain questions of state law for state courts, the state legislature, and others to set. And we can't manufacture a federal due process claim out of a purely state law question without running afoul of the basic habeas jurisdictional statutes. That's the problem. It's, you know, some things these days really do belong to our state courts and to our state legislatures, and they don't always mess it up. We don't agree with them, maybe, but they're still questions of state law. And if we start getting in and saying, no, this interpretation is wrong, or this interpretation, state courts interpreting state law are still dealing with a state law question. I don't see how you get around. How do you get around the fact that at bottom, questions of parole eligibility are matters of state law? And the federal habeas doesn't deal with that. That's the basic question.
Judge Wilkinson, my response would be absence of interpretation in this case distinguishes it from Barclay v. Florida, distinguishes it from Swarthout v. Cook. We're talking about a situation in which there is a statute on the books that has not apparently been interpreted or applied as to my client either way. And he's been litigating this claim for 18 years. And respectfully, I would submit that that grinds against what the Supreme Court called the touchstone of due process. Again, his claim is a fundamental due process violation. He's asking for protection of South Carolina state law. And
but they actually, I think it's the Phillips decision, they actually have interpreted it. The state courts have expounded on it. Now, you know, you may disagree with the way in which the Supreme Court, with the way in which the state courts did it, but they did look at the statute 16-1-60B. Whether you agree with them or whether you didn't, they looked at it.
And Your Honor, yes, I do believe that they acknowledge subsection B, but they do not acknowledge section 266, which is the savings clause provision in the same act that vests my client armed robbery as nonviolent. And I do see that I am over time, and I'm not sure I have any time to save for rebuttal, but if this court has no further question.
Well, you've got some time for rebuttal.
Thank you, Judge Wilkinson.
We look forward to hearing from you there. All right, counsel.
Very much. My name is Matthew Buchanan. I'm General Counsel of the Department of Probation, Parole, and Pardon Services, representing the state. With me is my co-counsel, Octavia Wright. May it please the court, I would start by saying that we do have the agreement that due process, federal due process would apply if the petitioner was parole eligible. And obviously that question is a state law question. So if he is parole eligible, then it would in fact be a due process violation to deny him parole hearings. But before we can reach that question, and the question here before this court is whether or not his due process rights were violated, this court would first have to rule upon a state law issue and have to interpret the state law 16-160B and the savings clause as the petition was brought up.
Does Van compel this result?
Your Honor, I believe Van says that the petitioner, well, it first speaks to Greenholz, where essentially there's obviously no right to parole. The federal constitution does not grant anyone the right to early release from an otherwise legitimate sentence. So Van says that it provides federal deference to state parole decisions. So I would therefore suggest that this court should defer to whatever guidance we do have from South Carolina regarding the interpretation.
Does it govern this case?
Van?
Just go to Van. Can we just make this decision based on that?
Actually, I think Van is appropriate, but I think Ramdis is actually more appropriate because Ramdis really does speak to this court's rulings regarding parole eligibility being a state law question. Parole eligibility is a determination of law, not fact, and therefore state law is the deciding factor on whether or not the defendant is eligible or ineligible for parole. And again, that is the question that this court must first resolve before they can get to the federal due process questions.
Have the state courts rendered a decision on this particular statute in your view? There seems to be some confusion about that.
Well, certainly we do have Phillips, which while not being perfect, because I will acknowledge that the Supreme Court did rule specifically on the ex post facto question that was raised, they did at least acknowledge it, and they did point to the fact that in that footnote that they said it is prospective only. It does require an interpretation but again, it boils down to this court would have to step in the absence of something that is more clear, but I think that this court should not. And another reason why this court should not do this is because the petitioner actually filed upon his receiving the notice in 2004 that he was not parole eligible from the Department of Probation, Parole, and Pardon Services. He appealed twice. He appealed once in the post-conviction relief court and also in the administrative law court. You would see in the record, the Joint Appendix 218, you have the letter from the Department of Probation, Parole, and Pardon Services in 2004. On the second page, it actually gives instructions on how to appeal. And it says that he has to appeal to the South Carolina Administrative Law Court. The South Carolina Administrative Law Court is the proper venue and a proper jurisdiction.
All right, so let me ask you this. If, let's say the petitioner here disagrees with the Phillips decision, as to eligibility. You're saying, what are you saying the remedy is?
I'm
You're saying
saying,
it's not federal habeas. What is the remedy?
well, his remedy was to argue this to the proper jurisdictional court, which was the administrative law court. You look at the decisions of Al-Shabazz and subsequently Furtick, those decisions by the Supreme Court of South Carolina state that the proper decisions or the proper venue is the administrative law court of South Carolina when it comes to parole eligibility considerations and questions.
All
So
right, now the administrative law court in South Carolina is the one that deals basically with questions of parole eligibility under state law. Is that not right?
that is absolutely correct. Yes, Your Honor.
And they have a background and expertise in that.
That is correct. Now,
And so it all comes back again to the question of whether someone is eligible or is not eligible for parole. And if somebody doesn't like the Phillips decision, there is still recourse to resolve this state law question of parole eligibility. But your basic point is that this antecedent question of state of parole eligibility, it remains, you can put it through this exercise or that exercise, but it remains a state law question,
absolutely.
which has to be answered first before you can get into any kind of habeas jurisdiction.
I agree. Yes, Your Honor.
And did the ALJ court in this case rendered some sort of a order or opinion?
It did. And then
And
the
then what-
petitioner
and then
elected
what
to
happened?
not appeal that to the Court of Appeals. I believe probably because he did get some response from Judge Keesley in the post-conviction relief action. He chose to put all his eggs in that basket and elected not to continue to appeal from the administrative law court.
Well, if
which-
that's the court that handles these issues, then
Yes.
they chose not to appeal. Doesn't that end the case there? I mean, they had the opportunity to address the issue of state law and they failed to do so.
That's what I would submit. Yes, Your Honor.
Let me ask my colleagues, I think we understand all the arguments here. Maybe it's best to throw this open to questions if Judge Agee or Judge Wynn has questions of you.
No questions, Your Honor.
No questions.
All right,
Right. Well,
let's
it's
hear
like
from the
win and
opposing
unknown.
rebuttal.
Time. So thank you very much, Your Honor.
Thank you.
Thank you. First, let me briefly address why my client exhausted. I believe that Mr. Buchanan somewhat mischaracterized the record on that point as to why he proceeded in PCR. And I do acknowledge that it has been confusing between whether you should proceed in ALC or PCR in South Carolina. At that time, the department was taking the stance that claims such as my client's, at least, which were so intertwined with a sentence, which sounded a bit more like an ex post facto claim, although that's not what he was raising, were better raised in PCR. And that is also noted by the South Carolina Supreme Court in the Major v. Department decision. Now, I do believe that, as I pointed to earlier, the PCR order shows that the courts understood the issue. And I would agree that the ALC completely punted on this issue and did not address it whatsoever.
Even if that's the case, and you assume that you could have brought state law interpretation claim to the PCR court, what's the proof that after that decision was rendered, that it was addressed to the South Carolina appellate courts?
So I think what you're asking is what happens after PCR in South Carolina. It was remitted to the Supreme Court of South Carolina, which issued an order and remitted her without opinion, affirming the PCR order and finally denying my client relief.
Shows that the issue that you raise here on the meaning of state law was addressed to the South Carolina Supreme Court.
The South Carolina Supreme Court had before it my client's PCR petition and the PCR order and the memorandum of law, the entire record that the PCR court had, which included the savings clause argument. And that, you know, this court would quite frankly be in a much better position today, and maybe we wouldn't be here if the South Carolina Supreme Court or any South Carolina court had actually interpreted the savings clause.
But that raises this question. Suppose the ALC court or whatever South Carolina court had said, you're not eligible for parole under state law, and that would still, we wouldn't be able to review that question if the South Carolina courts had said you're not eligible for parole. Those are still state law rulings on state law questions, and we can't say to the state courts, well, you were wrong on how you looked at this question of state law. So I'm saying, even if you received, I realize there's maybe some disagreement about the meaning of the Phillips opinion, but even if you had received a negative response or a ruling from the state saying you're not eligible for parole, state courts, state parole boards, administrative law courts, they make those rulings all the time. And they make those rulings that under state law, someone is not eligible for parole. And I don't see how we get the authority to second guess that in view of the Supreme Court's repeated admonition that habeas is a basically intended to address the deprivation of federal rights. And if there's one thing the Supreme Court of the United States has been clear about, is that state law views on questions of state law are final. And it still seems to me to be a real hurdle for you to get over the fact that we can look at it from this angle or that angle, but at the close of the day, it's a state law question.
Sure, and if I may briefly respond, and I would like to distinguish Van and the Angelone cases. In those cases, first, Virginia Department actually had, and Your Honor noted in the opinion, a level of discretion in applying the parole eligibility standards, such that this court even questioned whether there was a liberty interest. That's not an issue in this case under South Carolina Supreme Court precedent. There is a liberty interest in parole eligibility in the state of South Carolina. And second, regarding those cases, the Virginia courts had a clear and coherent, and again, I understand that to the extent that they make small errors, federal courts declined to intervene, but the Virginia courts had a record of interpreting the statutory language, common act, transaction, or scheme. We simply don't have that in this case, which is why I would respectfully submit that this would be more akin to a state enacting a parole scheme, having laws on the books, that it's failing to apply to citizens. And again, a limiting principle here for it to rise to a federal due process violation. First, it would be rare that a state would do that. That's part of what makes this an odd case. And second, it would be rare that it would actually strip that person of a state created and federally protected liberty or property interest. And I see that my time is up. I would, if there are no further questions, I'd be happy to answer any other questions.
Well, I just want to thank you for your argument. You court appointed.
Thank you, Judge Wilkinson. Yes.
Are you court appointed?
Yes, Judge Wilkinson.
All right, then I would like to say we really depend upon our court appointed lawyers to do a good job and make an excellent argument. And you sure have done that. And so I want for the quality of your presentation. Thank you very much.
Thank you very much, Judge Wilkinson.
We will we'll adjourn court until tomorrow morning, I guess. And sorry we can't shake everyone's hands, but the reasons are apparent. Okay, I'll ask the courtroom deputy to adjourn court. And we'll take a 5-minute recess and then we'll convene in conference.